quiet everyone down. Never knew I had this power. Well, this is a marvelous moment in the life and spirit here at Penn Law School. I'd like to welcome everyone. This is the Owen J. Roberts Memorial Lecture, one of the oldest, certainly the oldest and most distinguished lectures here at Penn Law School. The Law School established the Roberts Lecture more than half a century ago to honor the memory of one of our most distinguished graduates, Owen Roberts, who bridged the worlds of academia and public service, epitomized the Penn Law ideal. He began his career as a member of the Penn Law faculty and ended his career as dean. In between, he was a practicing attorney, a federal prosecutor, the prosecutor in the famous Teapot Dome scandal, and an associate justice of the United States Supreme Court for 15 years during the era of the Great Depression and the Second World War. His career was remarkable in every way, one of which I must say I find particular poignancy. It is not every Supreme Court justice who retires from the court to become the dean of the University of Pennsylvania Law School. This is a career move for which I have some affection. Roberts' career was astonishingly energetic and impactful. He was constantly engaged in the vital issues of his day and was a tremendous influence for good in the world around him. That is one reason it is so very fitting that we welcome Amartya Sen to deliver tonight's lecture. In many ways, Professor Sen requires no introduction, but I'll do it anyway. He is without question one of the leading intellectuals of our time. A recipient of the Nobel Prize in Economics for his contributions to welfare economics, social choice theory, and issues of poverty, he is currently the Thomas Lamont University professor and professor of economics and philosophy at Harvard University, and was until 2004 the master of Trinity College, Cambridge. Professor Sen's research has ranged over a dizzying array of fields, from social choice theory to economic theory to ethics and political philosophy to welfare economics to theory of measurement to decision theory to development economics to public health and to gender studies. The extraordinary breadth of his scholarship is matched by its brilliance and depth. Over 4 decades, he has written or edited more than 30 books and hundreds of articles. His publications challenge the foundations of almost every subject in which he engages. It's been said that the strongest feature of his work, economics and philosophy together, are ethics and a sense of common humanity. Indeed, Professor Sen has been called the conscience of his profession. While the work of most economists is protective of private markets and is concerned primarily with matters of efficiency and increasing the size of the economic pie, Professor Sen has looked rigorously at matters of equity and how that pie is divided. His keen analysis shines a bright light on income distribution and how best to promote social welfare. His work on the causes of famine, for instance, has shown why thousands might starve even when a country's food production has not diminished. His scholarship has also identified a more honest metric to measure equity and welfare. Arguing that simple measures of GNP were not enough to assess the standard of living, he helped to create the United Nations Human Development Index, which has become the most authoritative international source of welfare comparisons between countries. Now that's all well and good, you might say. But over the years, the Roberts Lecture has hosted some of the most distinguished members of the judiciary and the legal academy. Why have we invited a philosopher and economist to speak this year, even one as distinguished and internationally renowned as Professor Sen? Professor Sen, we've been waiting for you. We knew that it was only a matter of time before your scholarship would take a legal turn. As we all know, all the important issues ultimately turn into legal questions. So with mounting enthusiasm, we have watched as your work in recent years has underscored with remarkable force, elegance, and articulateness a profound truth. That you can't talk about economic development without talking about justice, and you can't analyze justice in developing countries without considering the legal regimes in place. In his work on justice, Professor Sen has argued that equality should not be measured the way economists want, by comparing a person or group's satisfaction or pleasure, nor should it be evaluated based on what his colleagues, the late political philosopher John Rawls, called primary goods. Instead, equality should be measured by attending to a person's capabilities, whether someone can read, lift water from a well, or function intellectually. Professor Sen will speak to us this evening on language, law, and human rights. He epitomizes the cross-disciplinary perspective we prize and champion here at Penn Law School and throughout the university. Through his work, we see how interconnected human knowledge really is. We see as well how the world's problems do not come neatly packaged, which is why Professor Sen's works with so much passion on the most fundamental problems that lie at the crossroads of economics, philosophy, and law. Now, I'm not going to spend time listing all of the positions he has held. As I noted, in addition to the university professorship, Professor Sen is a senior fellow at the Harvard Society of Fellows. He served as a full-time or visiting professor at a dozen of the world's most prestigious universities. He served as president of the Econometric Society, the American Economic Association, the Indian Economic Association, and the International Economic Association. Professor Sen, who was born in India, is truly a global citizen. The awards he has received, in addition to the Nobel Prize, testify eloquently to his international renown. Again, there are too many to list, but let me just note, most recently in 2011, he became the first non-U.S. citizen to be awarded the National Humanities Medal, and just this year he was made a commander in the French Legion of Honor. As someone who grew up on a campus, the son and grandson of a Penn faculty, I identify with the fact that Professor Sen, who spent his entire adult life on university campuses, was also born on one. His father taught chemistry, and his maternal grandfather was a renowned scholar of medieval Indian literature. Of his upbringing and Indian heritage, he has said, "It is impossible to grow up in India without becoming aware of the economic problem. I wanted to do something relevant." I think that everyone in this room agrees with me that the idealism of his youth has been the pole star of a mature and remarkably clear moral vision that has shaped an extraordinarily productive and significant academic career. Thinking about how influential his scholarship had been, I was reminded of something Justice Roberts once said about his esteemed Chief Justice, Charles Evan Hughes. Hughes, he said, developed arguments that often persuaded his brethren on the court to change their minds and side with him because of his deep knowledge of the facts of each case. Professor Sen's deep knowledge and profound insights have changed the way policymakers, government officials, scholars, and the public think about a vast array of social, economic, and legal problems, from poverty and famine to gender inequality to international human rights. As The Guardian once put it, Sen is a rare example of an intellectual who's had a major effect on politics. He will speak tonight about how constitutional interpretation depends on the nature of the language in which the provisions are expressed. Like everything to which he puts his mind, I'm sure we will not think about the topic the same way after he's analyzed it. It is my extraordinary pleasure to welcome this year's, the 2013 Roberts Lecturer, Professor Amartya Sen.
First of all, I'd like to say how deeply honored and grateful I am to have been invited to. Am I all right?
Yes, that's happening.
Okay. To have been invited to give this talk. The distinction of the lecture series is quite deserving. I think, with due modesty, I should. I think much deserved modesty. I said that I will. But you should know, of course, that I am not a lawyer. And I hope it will not be painfully clear that that is the case. But since throughout my life I've never tried to stick to my subject, this won't be the only exception. The second point to note is that I actually slightly miscalculated. I hadn't carefully looked at the fact that the intention was to have a 40-minute talk and then Q&A, and I wrote a rather longer talk. So I'm going to ferociously cut it, and so do something which I actually normally like doing anyway, rather than reading it speaking on it. And that's what I'll try to do, and I think Dean Schlitzen, I'd like to say how extraordinarily kind he has been, thank you very much, and would give me some signal saying that I'm overstepping my boundaries of time. So I begin with a concern that bothered the makers of the Constitution of independent India when the British Raj ended in 1947 and India decided to establish a democratic constitution, which came into effect 2 years later. When the Constituent Assembly took the task of forming the constitution of the soon-to-be-born Indian Republic, the pursuit of justice was among the major guiding principles that the lawmakers faced, even though there was some lack of agreement among the new lawmakers themselves about how justice would be best promoted, or indeed how it should be best interpreted. One of the major concerns with which this talk will be much related, to which this talk will be related, concern that engaged the Constituent Assembly was how to combine, one, fixed legal rules as a constitution must demand, and two, a built-in flexibility in the constitution so that new ideas that win future argument can be accommodated within an appropriately responsive constitutional framework. A constitution is, in one sense, a collection of words. And the philosophical problem involved in interpreting a constitution, whether in India or in the USA, are among the concerns that makers of the constitution have to confront explicitly or by implication. I'm actually giving another law lecture later in October in the Library of Congress. They have a jurisprudence lecture every 2 years. I think it was given by my friend, dear departed friend, Lamont Golkin was the first one to give it. And I think I'm the third one. And there I go a bit more into the US constitutional history, which I won't have an opportunity of doing today. There are at least three major problems here. First, there is the central philosophical understanding, clarified in particular by the philosopher Ludwig Wittgenstein, that the meaning of words has to be seen in terms of the rules that govern their use. If a constitution is to survive over time, the makers of the constitution therefore cannot overlook the possibility that rules governing uses of words can change quite substantially over time. As Samuel Johnson noted in his preface to his famous Dictionary of English Language, 1755, I quote, "Language is only the instrument of science, and words are but science of ideas." He went on to say that over time the science can decay, and that the meaning of words do change over time. Second, the rules that reflect the use of a word may not be uniquely defined, even in Wittgensteinian terms, and there may well be scope for argument as to which of the permissible rules, Wittgensteinian sense, will be appropriate in interpreting a law, or even the constitution. The right, for example, to be quote-unquote treated with dignity, big in the Indian constitution, or the right, quote-unquote, to bear arms, quite important right now here, can each have a cluster of alternative definitions. And there is an issue of which of the permissible interpretations one should look at and how we think about it. Third, in choosing between alternative interpretations of words, there is need for reasoning, which demand on one hand empirical cogency, as well as ethical plausibility. To illustrate the empirical connection, let me choose an example from India of affirmative action. The Indian Constitution was, I believe, the first of its kind in the world to incorporate very specific provisions of reservation of jobs and positions of influence and even seats in parliament initially for people from the lowest ladder in caste and tribal hierarchy for the purpose of generating social mobility. And this has been a subject of great deal of debate in recent years as what the parliamentary representation has been weakened or nearly abolished, but in jobs, in civil service, in educational establishment, those quotas remain. If empirical evidence of the way these provisions have worked turn out to show, I'm not saying that they have done so, but some people do, like my friend Andre Bethey, one of the leading sociologists in India, claim that it hasn't worked, that the purpose is not being served very well by this kind of a provision, and an alternative way of encouraging social mobility would be more efficacious, then the provisions, the question now arises, can they be interpreted in the light of the motivation behind the provisions rather than the wording of the provisions themselves. A reason-dependent provision is quite different in this respect from a provision that works independently of reasoning about its effects and other correlates. Now that's just one example of the empirical connection. I think and maybe in Q&A we could discuss that. I mean, the right to bear arms, the empirical connection, what the result of different rules are, cannot but a major factor in this debate, at least in one way of looking at it, the way I'm trying to present it. But let me look at the ethical connection now. And here, since Dean Schitz very kindly attributed to me having conscience among rare an economist, I never like that expression. It's my second worst expression that I like. I think the worst, I won't even tell you what that is. But I think economists have had conscience all the time, actually. I think my problem is that they often get it completely wrong. I believe they are doing. I mean, the European economists are absolutely full of conscience. But just look at the mess they have made. It isn't any absence of heart, it's an absence of thinking clearly, I think. So I just take some pleasure in I had already got it before I heard you, but I thought that I would begin by quoting the founder of modern economics, namely Adam Smith. He pointed out in the Lectures in Jurisprudence and also in his other books, namely The Theory of Moral Sentiment and The Wealth of Nations, that you cannot interpret these legal provisions without bringing an ethical consideration into the story. Not because the laws are not formulated, but formulated even as they are, cannot but leave you with an opportunity to argue as to how best to interpret it. Then, that one question which may be different from now, but also even then there could have been alternative interpretations. He goes into that subject quite well in the Lectures in Jurisprudence, which were not published during his lifetime. These were lecture notes of his students. But the Theory of Moral Sentiments, which was published. And that goes extensively into it. I'll do a commercial here, since the 250th anniversary, quarter of a millennium edition of the Theory of Moral Sentiment, I see as my edition, since I wrote the long introduction. Both in the introduction and, of course, in the book, you see how strongly Smith was concerned, the need for bringing in moral reasoning into understanding what might otherwise look like just matters of fact. Indeed, in 1776, when the American Declaration of Independence was being promulgated, Smith, in the very same year, in his book Wealth of Nations, talked about some need for basic moral reasoning, interpreting the importance of such things, for example, as the pursuit of happiness. In this context, he commented, and it's important to recognize, since Adam Smith has often been seen as the advocate of a no-nonsense pursuer of market efficiency, paying no attention to social fairness or equity, is recollecting what he did say on this, and I quote from Smith, "No society can surely be flourishing and to be seen as happy, of which the far greater part of the members are poor and miserable," unquote. Indeed, it's not adequately recognized, given the championing that Smith gets from the hard-nosed, I'm a great believer in the market too, but I'm not a market-only position, but hard-nosed marketeer, that even Smith's severe criticism of state intervention in many fields of economic activities drew not to any general aversion to state as an actor, but to his theory, political theory, as to what he thought was the nature of the state, namely that it is not impartial. So I think that is a huge confusion. It's not that he thought state intervention will always go wrong. He thought the state intervention will sometimes go wrong, and there Smith was never a man for a modest statement, so he always liked exaggerating things. So he made quite a strong statement as to why the difficulty is that the state is run by the masters rather than the workers. He sounded outbeating Marx on that. And I quote from the Wealth of Nations. "Whenever the legislature attempts to regulate the differences between masters and their workmen, its councillors are always the masters." That's his complaint. "When the regulation, therefore, is in favor of workmen, it's almost always just and equitable. But it is otherwise when in favor of the masters," unquote. That's a big part of the politics of Smith, which I think we missed a lot in the literature. The Smithian reasoning draws both on epistemology, what would regulations favoring one group or another actually produce in the society, and on ethics, what outcomes would be acceptable in the light of demands of fairness and justice. Now, from this point onwards, I'm not going to read very sparingly to cut time. So I think here we come in to one of the major contemporary battles, or certainly one of the battles in the United States concerning the interpretation of Constitution and what is sometimes called originalism, namely taking an original view of the Constitution. Now, I think originalist view in some broad sense must always be right, because if you're trying to interpret a fixed document which was there at the origin of the discussion, you have to be an originalist in that sense. The question is, what of the original you're trying to preserve? That's the issue. Actually, and here, since I'm cutting it, I shouldn't go on referring to my own writing, but I did give something called the Herbert Hart Lecture, which came out in the Oxford Journal of Legal Studies in 2011, where I go into that question of originalism in particular. And originalism has many supporters. I believe Justice Scalia in the Supreme Court could be seen as one, as well as critics of it. Justice Breyer would probably be a good example. But there are difficulties also within the originalist school as to what is it that you're trying to preserve. There's considerable debate on how much freedom, indeed duty, the judges should have in bringing about the appropriate reorientation in the application of existing laws, and what line, how they should be guided in this. The question that does arise is what is to be preserved in the original constitutional process, the intentions behind it, or the specific words chosen in the Constitution. It was the former route, intentional, that was taken by the founding, that's how Stephen Calabrese, who is himself a very committed originalist, describes Robert Bork as the intellectual grandfather of originalism. Since I'm grandfather of 4 children, I'm not absolutely certain that that is a very active position. There was an active position at some stage. But then it becomes a very leisurely and very pleasant position. But I don't think that's the way what Calabrese meant about Bork. He meant really grandfathering it. The view that Bork presents include the insistence that judges today must, I quote, interpret the Constitution's word according to the intentions of those who drafted, proposed, and ratified them. Against that, Stephen Calabrese, and I ought to make that clear, that Stephen Calabrese is not to be confused with Guido Calabrese, whom I knew a long time ago, and when I first started reading Stephen Calabrese, I couldn't believe that I'm reading the same person. The answer, of course, is that I wasn't. So again, that Stephen Calabrese says, I quote, "The meaning of these words and their application to present-day problems depends in the end on what the American people think they mean acting over a long period of time through our 3 branches of constitutional interpretation," unquote. I would argue that Calabrese is much more persuasive in rejecting the Borkian intentionalist view of originalism, though I think in that context he also shows a bit of the baby out with the bathwater, than he is in establishing his alternative approach of originalism in sticking to the words used in the Constitution, no matter what these words have come to mean today, rather than at the end of the 18th century. Even though Bork's focus on intention seems hard to defend, if intentions were supposed to include, as Calabrese says it must, unenacted idiosyncratic intentions of particular framers, unquote. I don't think that's really what meant. We can look for something more substantial, what in my Hart lecture I call the constitutional motivation. It's not just the intention of what is it that we try to do. We vote for various things for all kinds of reasons. Sometimes for log rolling reasons, sometimes for arriving at an agreement with others. Cass Sunstein discussion about the importance of not fully argued differences which lead to agreement, of course, indicates that the intentions are really quite a shady territory. But constitutional motivation is certainly something that is understandable, and I hope we can, even if there are doubts about that, we could discuss that. Now, if you take the view, and I'm skipping here something, that the constitutional motivation you're looking for, you have to ask, even dealing with things like right to hold on, as to what is it that they were trying to do, what kind of a society they were trying to capture. And then you don't interpret it only as what is it that it includes, whether it includes one kind of killing machine or another, but what is it that the Constitution makers were trying to bring about. Now, if you take that line, there are clearly 2 distinct evolutions that we have to be aware of over time. In addition to the fact that we come to know a lot more about things today than we may not have known then. I mean, it's amazing to think that we should attribute to people, even the cleverest people in the 18th century, a full knowledge of cause-effect relationship of social things before none of these social experiments have been launched, studied, or looked at. And if you take the view that somehow that epistemological enrichment over time has to be ignored, that's a huge problem. But in addition to that, there's a contrast between, over time, as societies change, I mean, the language is also changing, but our ethical values may also be changing. But there's a distinction here between these two things. One, the development of particular values and priorities that are compatible with what I would call constitutional motivation, in American case particularly facilitating a democratic, tolerant, and a participatory society. And two, the progression of language and rules for the use of words, which goes on its own logic, applied in particular to the word that the Constitution used in the text. The two processes will almost certainly be linked within a given country, but it would be rather credulous to expect that the two must be, in some sense, always congruent even within a given country. In placing ourselves in the hand of the contemporary meaning of words and texts, which is what Stephen Colabresi recommends, we are being asked to leave the choice of substantial ideas to the evolution of linguistic rules and nothing else, just taking those words seriously. I mean, it's amazing how many words have changed in their meaning in their small way, but if you think big ones, and if no constitution would be involved in that, as someone coming from India, and there's always a problem, you see some people, children having little swastikas on their hand. The word swastika, of course, doesn't mean anything like what it's come to mean. Swastika is derived from suasti, good existence. And one of their words is that swasti is to be preferred to sukh, namely, instead of pleasure, look for the good life. Now that's not the way swastika means now. Now that's a radical change. I had to restrain one of the members of the Indian Economic Association, I think she was secretary of that, from calling her son Aryan, because that means quite a nice word in Indian, mean noble in ideas. But the fact that that wouldn't do, the word doesn't mean anymore that in English. So I think this whole idea that somehow we have to be captured by the word, and no matter where it goes, we have to adopt those ideas, I think that, to me, seems extremely suspect, to treat that as a fixed point. The central issue in wanting to be faithful to the original is to decide what would be sensible to preserve from the original. The choices considered are, one, the words, taking them to mean whatever these old words mean now, as suggested by Colabresi. Two, the intentions of the framers of the Constitution, as presented by Bork. And three, the constitutional motivation that led to the formulation and signing of the Constitution, taking note of the purpose underlying it. In my talk, to be given yet, namely in what I intend to speak about in Washington in October, in the Library of Congress, I give also examples to indicate how various people, particularly Philip Livingston, for example, just the day before he signed the Declaration, makes clear that there's no way you're taking away their right to reason about interpreting what is it that we are presenting. That's a completely different thing from just a job lot of words, and that's what we're stuck with, and that's what the Constitution means. Anyway, given the shortage of time, I leave that issue here, and I've got two more. Basically, I think I won't be able to do two. I'll do one more. I was going to talk a little about justice, having written actually I'll say a little bit about that, and a little bit about human rights. But in the theory of justice, it had been a subject of intense debating in political philosophy over the last half a century. And this is quite important, even for the constitution making, because it's quite clear from the constitution makers' statement that they are in India, I'm talking about here, and it would apply to America too, but they were much more consciously looking at the interpretation of what justice should demand. So theory of justice in this sense, which is not only a philosophical issue, which is how I try to approach it, seems to me to have implications that extend far beyond into jurisprudence, naturally as the word justice would indicate. Now, I've tried to argue in my book that the entire approach of standard Hobbesian approach of basing the idea of justice on a social contract is wrong, at least on three grounds. One, it looks only for the perfect society, doesn't tell you anything about whether something is getting better or worse, how do you judge them. Secondly, it assumes that somehow we would have an agreement. Once we take away our private interest, we'll all have an agreement on what the fair society would be. And in a chapter in my book called Plurality of Impartial Reasoning, that it is possible to be completely impartial and yet arrive at different conclusions. Nothing taught me more on that than the classes I used to teach with my friend Robert Nozick, because I think he was being very impartial, and yet he and I, our intuitions went very different. I mean, I'm a libertarian too in some respect, and he was of course in every respect. But I think our intentions diverted from that point onward, and it isn't because I didn't think that Bob Nozick was not being impartial. I think he thought that that's what reasoning will take you in a state of impartiality. Now, instead of that, let me just say how completely variable the idea of what is the just thing to do would be by giving an example. So what I'm giving is not Indian Constitution in 47 making of it, but from a 4th century play in India called Mithya Katika, which means the little clay cart. It was written by a radical playwright called Sudwarka, very radical, very critical of inequality, of power, of income, and other forms of society, and he suffers a lot from it. At one level, Mithya Katika is a moving love story involving this upright but not wealthy citizen called Charudatta, to whom I was referring to, and his lover, Vasanta Sena, who is actually a very beautiful and kindly courtesan. So the social barriers are quite large there. Their love for each other makes them face many social barriers, and indeed in the process there were attempts to kill them both. But despite them, they are ultimately united. And this is the principal romantic theme of the play. But the play is enormously involved with people suffering from the social malpractices of the rich and the powerful, who behave atrociously towards the less privileged. And the play, it can be seen as a social critique, but it also had a certain view of justice. Towards the end of Mithya Katika, the misrule and abuse of power is successfully challenged by the people with the defeat of the old rulers, and the play ends with the scene in which the overthrown tyrants and villains are being judged and sentenced. In the new regime, Charudatta, our hero, is given the power to govern the local territory and asked to judge what punishment should be given to the culprit who had earlier attempted to murder him, and also Vasanta Sena. Charudatta understands that the villain could indeed be severely penalized, which is the existing law would demand. He also recognized the fact that throughout the play is quite clear that he's a very non-vindictive man. That wouldn't do. If he were to be lenient, he has to give a reason, which is not just saying that I believe it couldn't be a kind of strongly exaggerated Christian or Buddhist position that it would be wrong thing to do. Don't do it, no matter what he has done. He has to give some kind of a social explanation as to why that would be the right rule. It's a wonderful play, by the way, to read. Charudatta explained in an expression that I thought was truly memorable when I first read the Sanskrit play at the age of 14. He says, "It is our duty to kill him with benefaction." Unquote. Wonderful Sanskrit word. Upakar hatasya kartavya. Kartavya is your duty. Upakar is helping him, benefaction. Hatasya is killing. Now, he argues for it, and he pardons this guy, not saying that everyone should be pardoned, not on any of that kind of ground, but on social ground. The pardoned would-be murderer expresses his grateful delight and leaves as a free man. In the closing remarks with which this play ends, Charadatta makes clear that his priority is not tit-for-tat justice, but to make the world go well, with prosperity, happiness, and security for all. It's fair to guess that the kind of killing by benefaction, upakaratesya kartavya, represents an idea that is a part of Charadatta's program of reform, restraining the temptation to mete out quote-unquote justice as to all. When an English translation of Mitsukatika, The Little Clay Cart, was staged in New York in 1924, the drama critic of The Nation, Joseph Wood Crutch, noted in a rave review in The Nation that he found the drama, quote-unquote, profoundly moving, actually comparing favorably with every other drama I had seen, and went on to declare his deep admiration for the play being, quote-unquote, so completely civilized. Crutch pointed to the understanding, and this is very important, because I think it's close to Shuddha's intention, that passion has to be reconciled, ultimately, with the decision of a reasoning intellect. Justice is ultimately a matter of intellectual assessment, rather than following the dictates of passion, a point of following a particular rule of tit-for-tat justice, a point that comes up astonishingly frequently, even in the contemporary world, as it did in 4th century India. What can we make of Charadatta's jurisprudence? The deciding issue here relate, I would argue, to the contrast between two concepts of justice. I try to discuss them in my book, and so here I'm going to be very brief. It's the contrast between niti and nyaya, two Sanskrit terms, both of which stand for justice in the classical language, but are rather different. Among the principal uses of the term niti are organizational propriety and behavioral correctness. In contrast with niti, the term nyaya stands for the comprehensive concept of realized justice. What happens in the world, including the various acts through which the world comes about. That too are included, including the institution too, but not just the institution. In that line of vision, the roles of institutions, rules and organization, important as they are, have to be assessed ultimately in the broader and more inclusive perspective of nyaya, which must take into account the nature of the world that actually emerges and not merely how it emerges. Charadatta's priority clearly is the pursuit of nyaya for a good world, rather than obeying the niti of fixed rules, including required punishment that are supposed to fit the crime in question. So now I take a deep breath and go 5 pages off and come to my last topic, and that's human rights. What bearing do all these discussions, well, I haven't given you all this discussion, but whatever you have heard, have on the idea of human rights? First, consider the issue of language and content. I've been discussing the way language can be seen to incorporate what is said in the Constitution, but of course the same issue arises in interpreting the language of human rights, claims that are thought to be shared by all human beings, not because of citizenship, but by virtue of their humanity, being people. The issue of language and the rules that govern their use is important to understand the nature of the dismissal of human rights that Jeremy Bentham presented in his essay Anarchical Fallacies, written in 1791-92. This was just after the French Revolution had made the Declaration of the Rights of Man. He dismissed that entire idea and said, I quote from Bentham, "Natural rights are simple nonsense. Natural and imprescriptible rights," and then he adds an American phrase, "rhetorical nonsense, nonsense upon stilts," unquote. I take it nonsense upon stilt means some kind of artificially elevated nonsense. Bentham said that a right must be a child of law, quote unquote. Bentham thundered with the sanguine confidence of a man who confounds an inflexible definition, his own, with a critical argument. that there can be other ways of thinking about claims that people have on each other's attention, which would generate demands on states and on international institutions, seemed unacceptable to the father of utilitarianism, and indeed to utilitarians, most utilitarians who followed him. And yet that is the way the claims of human rights have typically been seen over the years. But here is a question about the use of words. If you are going to follow Wittgenstein, how are the word rights, or human rights, or natural rights, how are they used? Bentham had no interest in that question because he had his own definition of rights. Consider the fact in 1911, when Christabel Pankhurst, a suffragist, a feminist, asserted in a speech in London that, I quote, "We are here to claim our right as women, not only to be free, but to fight for freedom," unquote, adding to this, "our right, this is our right as well as our duty," unquote. Did she communicate something in that statement? Indeed. And she did that despite the difference between her use of the term right and any legal concept of right that could be sustained as a claim in any then existing court of law. Women did not have the right to vote in Britain in 1911, nor would that right be achieved until 17 years after Pankhurst's speech in 1928. An immediate question that is raised by the duality of the idea of rights concerns the connection, if any, between the two types of users of the concept of rights, the one based on legal force and the other offering moral and political motivation. And the human right, as it originally emerged, came on the first ground, and then it led to a motivation for actual laws to be undertaken. In a wonderful book called Inventing Human Rights, the historian, Lynn Hunt, shows that despite the intellectual opposition to the idea of natural rights coming from legalists like Bentham, it turned out, I quote, to be easier to accept the natural quality of rights than their equality and universality, unquote, which is where the problem stuck in Lynn Hunt's analysis. The idea of natural rights was well established in the 18th century world, even when they were seen only on the basis of legislation rather than having the force of a legal right already before legislation. With that background, the American Declaration of Independence had invoked in 1776 the force of the rights of human beings in general as a kind of foundation of the American Constitution, which is to be formulated. The profound influence of the American Declaration on France and other countries in Europe was clearly identified by the French revolutionary theorist, and indeed the founder of my subject, social choice theory, the Marquis de Condorcet, a mathematician but also revolutionary theorist in Paris, in his essay, Condorcet's essay called On the Influence of the American Revolution on Europe, unquote, published in 1786, shortly before the French Revolution. And Hunt clarifies and affirms that the American Declaration of Independence had this profound impact on French thinking, and indeed on rest of European thinking, English too. But as he also points out, right did not get a special place in the American Constitution in 1787 and had to be incorporated to the first 10 amendments to the Constitution in 1791, leading to the Bill of Rights. Aside from this delay, the American Bill of Rights did not share the invocation of universality of the Declaration of Independence that 1776 declaration had, and was, as Hunt notes, I quote, a deeply particularist document, unquote. But meanwhile, the French had gone ahead with a different approach. The French Revolution had occurred and human rights in a broad form had been enunciated in 1789. Extraordinary things happening there. The use of wording also changing. I was looking at the Constitutional Assembly papers. A student of mine gave me these 16 volumes of that, and my heart sank when I first saw them. I've been reading with the greatest of joy, and one of the ones which I like very much, there's a character called Minu Masani, who who was then a socialist, and every time he speaks, he begins by saying as a socialist. And then he changed his politics and became the founder of the market fundamentalist conservative party called the Swatantra. His move navigated. But there's a lovely statement here when he's commenting on exactly the change of meaning of the word thing. And he said, fraternity. The French used it so much at the time of the revolution. But given how the fraternity was treated in the reign of terror that fought the Salud, we have to decide that the word fraternity has completely undergone its meaning. And then he ends by saying, so much so that when I introduce my brother, I describe him as my cousin. The Bill of Rights in the form of legislative requirement do, however, have a status, a legal status, and human rights as claims on what to put into legislation do not have. The Oxford legal theorist Herbert Harter, in whose honor I gave that lecture to which I referred, argued nearly 6 decades ago in 1955 that people, I quote, speak of their moral rights mainly when advocating their incorporation in a legal system. Hart took a natural right in this sense as a parent of law, rather than like Bentham as a child of law. Generating argument, and parent of law is the way to think about the one sense of the right, the human rights, and child of law is the right way to think about what happened after legislation, namely the legal rights that ensue from that constitution of the lawmaking. Generating arguments and inspiration for legislation is certainly one way in which the ethical and political force of human rights has been constructively deployed. The Universal Declaration of Human Rights in 1948 by the newly established United Nations was seen by its sponsors, particularly by Eleanor Roosevelt, as a template for actual legislation to be taken on board by individual states. And to a considerable extent, that has actually been happening in Europe and in America and Latin America and Asia too, in addition to other motivating influences that powerful international declaration exercise. In my Hart Memorial lecture, I have argued that Hart's interpretation may be right, but you can extend it because there are many ways in which we can exercise greater, we can make what we see as human rights better fulfilled, not just by legislation. Media discussion, public agitation are among them. It's worth bearing in mind, for example, just as an example, that the Human Rights Commission in India and South Africa are constitutionally recognized bodies, but in Pakistan it's nothing, it's just an NGO. And yet it has had a huge impact by just drawing attention to it in the media. I mean, the big case was in the Swat Valley when a girl was caned by the Taliban and the Pakistan army was unwilling to intervene. And it is a Human Rights Watch activist who, at the risk of his life, actually photographed it all, while, photograph meaning videoed it all, while in fact pretending to make a telephone call. And when that video was released in the Pakistan television and the cable channels, it was very difficult for the army not to intervene. What changed here wasn't any legislation. What changed here was a simple media pressure. So I think this whole approach that Hart started can be extended much further. Now, so to end this section, and I'm going to stop there, and I'm really looking forward to the discussion, that what I would like to say is that we have to think of human rights as what it stands for, that it has a sense which Bentham failed to see. It wasn't missed by his contemporaries like Mary Wollstonecraft, but on top of that, we have to see that in order to bring this about, you need a great deal more than legislation. But when that point comes through in Mary Wollstonecraft, 2 books, radically. I think Mary Wollstonecraft is probably the most underestimated thinker of the 18th century. And in the context of gender too, he points out that yes, of course, we have to have equal rights in many ways, but that's not the only issue. We have to change the public discussion. You have to change the media coverage. You have to change what agitates people, etc. And these are the really big issues that we make. So I think I will stop there. It has been a rather fragmentary speech on 3 different subjects, but then again, I did try to cover all of them quicker. Perhaps not quick enough, but quicker.